the ignition interlock device and the statute that went into effect on that in January of last year, this is such an enormous direct and, in a certain sense, collateral consequence for defendants. A lot of confusion out there about how the statute actually works. So I want to talk to you not only about the mechanics of the statute, but also the mechanics of the device so you can appreciate it in context with the statute. Now, the first thing I want everybody to understand is the actual statute, which gives you the nuts and bolts of what you're supposed to be doing, is set forth under 39450.16. 16 is actually the public policy statement by the legislature. The actual nuts and bolts of what you're supposed to do starts at 17. The body of the 39450 statute has some minor language in there mandating it, but the actual nuts and bolts of what you do is in this particular statute. The days where you could utilize the option of a registration suspension in lieu of the use of an ignition interlock device on a defendant's car are now long gone. And with one minor exception, everyone who's convicted of drunk driving is going to be required to utilize an ignition interlock device on his vehicle. Now, when I say everyone, these are the classes of people I'm speaking about. Anyone on a first offense who is convicted and has a BAC of .15 or greater must have the ignition interlock installed on his vehicle. Anyone convicted of a refusal to submit to breath testing on any stage, again, mandatorily must have the device installed on the vehicle. Also mandatory for second and third and subsequent offenders. Now, the statute previously was tied into registration and ownership. That's out now, and the approach taken by the legislature is a much more amorphous one. That is that the responsibility for the installation of the ignition interlock device by the defendant is on the vehicle or vehicles that he principally operates. That is not defined anywhere in the statute. It'll have to develop through the case law, and the Motor Vehicle Commission really doesn't know what they're doing at this point, and they're still kind of clinging to vehicles that are registered to a particular defendant as being required to have the ignition interlock device. You may wind up getting into a fight with the Motor Vehicle Commission on that issue by virtue of the fact that although your client may be the registered owner, it's not a vehicle that he principally operates, and therefore not required under the statute to have an ignition interlock device installed. The way the statute works from a mechanical standpoint is as follows. After the defendant has been sentenced, the court's sentence will require the defendant to have the ignition interlock device installed on the vehicle or vehicles that he principally operates immediately, meaning like today, all right, or tomorrow morning. This notwithstanding the fact that in all these cases there will be a term of suspension the defendant is going to be serving. So it doesn't matter the defendant's on the revoke list. He has to have the ignition interlock device installed on the vehicle he principally operates right away. It will continue on for the suspension term and then for a determinate term following the expiration of the suspension given in court. For a first offense, that ranges between 6 months and 1 year. For second and subsequent offenses, the range is between 1 and 3 years. So just by way of example, if the judge wanted to give someone a break on a first offense, that individual would serve, let's say, a 7-month suspension. During that time period, he'd be required to have the ignition interlock device on his vehicle. Then, following the completion of the 7 months, he'd have to keep the device on his vehicle for another 6 months. Again, the range being 6 months to 1 year. Now, you've got to tell your clients, if you do defense work, it's more than just having the ignition interlock device installed in the vehicle. Your client may not operate any vehicle at all in New Jersey that is not equipped with an ignition interlock device. So if your client is going to do something where it requires some type of professional driving, whatever vehicle he determines to drive has to be equipped with the ignition interlock device. All right? Make sure your clients know that because they want to rent a car or rent a truck or drive a delivery truck or a police car or something like that. Those vehicles have to have an ignition interlock device installed on them. Your client's driver's license, when he receives it back from the MVC after the completion of a suspension term, will reflect that the license is restricted and that he's only to be operating motor vehicles that are equipped with the ignition interlock device. It's a separate traffic offense now to be stopped in operating a motor vehicle that does not have that type of device in the vehicle while you're operating. Now, there's an exception in the statute, and this is the only time you can really avoid this sanction. This is for individuals who have BACs on first offenses that are less than .15, all right? When you have an individual who has a BAC of less than .15 with a first offense, the judge now maintains the discretion under the statute as to whether or not to order the ignition interlock device. Obviously, especially if you're dealing with a client who has to drive for a living or is planning on driving for a living, you're going to really want to pitch very hard if you're a defense attorney for the judge to exercise his or her discretion not to impose it. There's one other kind of quirk in the statute. I can't imagine this is purposeful by the legislature. It seems to me this was done by inadvertence. But if your client is ordered to impose, have an ignition interlock device imposed on his vehicle when his BAC was less than 0.15, in other words, the judge exercises his discretion in favor of having the interlock device installed, the obligation to install it does not happen until after the suspension term has run out. I don't know why they did it that way. It's just one narrow exception in the statute. So just kind of keep that in the back of your mind, although that would be a very bad outcome for your client if that happens. Now, in terms of the nuts and bolts of how your client goes about getting himself hooked up with a provider, the Motor Vehicle Commission has authorized 6 different companies around the state to install ignition interlock devices, and each of these companies has multiple presences throughout the state. The Motor Vehicle Commission has on their website the addresses of all these places. You can just go on the internet too. I suggest that your clients shop around for the best deal that they can get, because there is some minor variation in the amount of that they would pay. Each of the companies charges a monthly fee. Typically, it's going to range somewhere between $75 and $125, depending upon the sophistication of the equipment. And by sophistication, I'm really just talking size. The cheaper models are going to be bigger and bulkier. The smaller ones will be the more expensive ones. When your client goes there, they will take about a 2-hour period to install it. It has to be installed by one of their technicians. And then your client will pay a monthly fee that will be charged to a credit or debit card. The instrument has to be brought back in every 60 days because it's a breath test, just kind of like the Alka test, has to be recalibrated every 60 days. And if it's not brought back in on a timely basis, it gives the user kind of like a grace period of 10 days after the time period is expired. But if he doesn't come back then, it just shuts the vehicle down, and the vehicle will not start for any reason until one of the technicians comes out and kind of does what he has to do to get the vehicle going again. Same principle in terms of payment. If they don't get their payment on time, it will shut the vehicle down until such time as the payment is made. Now, the instrument is looking for a BAC that is less than 0.05. That's the magic number. So when an individual gets into the vehicle that's equipped with an ignition interlock device, he or she has to provide a sample of air for the instrument. And the instrument's going to check what the BAC is in that air sample. If it's less than 0.05, the vehicle will start in its normal fashion, and you can drive away, probably to the liquor store. While you're driving periodically and on a random basis, the vehicle will ask you for samples of your breath, and you'll have to do that. Again, this comes at random time periods, so it may be fairly quickly after you start driving away. Interesting, then, makes New Jersey one of the few states in the country where you cannot text or use your cell phone while you're driving, but you can take a breath test, right? Keep that in the back of your mind the next time you're thinking about how wonderful New Jersey is. If you submit a sample of breath before your vehicle has started in the morning that is 0.05 or greater, you get a lockout of your vehicle in the sense that the car will not start. You won't be able to submit another sample for at least 1 hour. The same thing applies if you submit a sample of air with a BAC of greater than 0.15 or greater, 0.05 or greater while you're driving. The vehicle doesn't shut itself off while you're moving the car. That would be terribly dangerous. What it will do is 2 things. Number one, emit this enormously loud, obnoxious sound that can only stop by turning the vehicle off. And number 2, get all the lights of your vehicle and the horn flashing, which in some sense may attract the attention of the cops for some reason. I don't know. I'm not sure. So you pull the vehicle over, shut the vehicle off. That'll stop the sound, but the vehicle will not start again for 1 hour. And after the hour passes and you submit a sample, it's going to be looking for a blood alcohol level that's going to be less than 0.05. What else is there to say about it except that it's expensive and inconvenient? Now, one final thing, there is a requirement in the statute that people who are at the 50% of the federal poverty line are entitled to a discount on their ignition interlock devices. It's set forth in the statute, and the discount is borne by the providers. So if your client is of marginal income level, mention to him that he's likely going to be entitled to the discount. He should investigate that, bring his tax return, and investigate that with the provider that he selects.